Hello once again, my friends. Thomas with Alpha Concepts here. You know, I feel like I'm often the bearer of bad news, like my sole job in life has been to rain on your parade, and I'm happy to say that today that's not the case. Today we have great news. We have a temporary injunction has been issued on the Illinois assault weapon ban. That was issued in the Southern District. There's lots of cases going on. This was specifically issued in the Southern District. This was the combined case known as Barnett, Harrell, Langley, FFLIL versus State of Illinois collectively. Before we jump into this video, we're going to talk all about this ruling, what it actually means, how long it might be in effect, because this is temporary, it's not over. Before we jump into all of this, guys, if you find these videos helpful, then I want to invite you to come out to one of our defensive shooting classes. We've got classes on the calendar from now out to October. We've got defensive pistol, defensive shotgun. I will make you a better shooter. I'm going to give you the opportunity to do things you can't do on the range, square range. We're going to be drawn from the holster, shooting on the move. All of those things that you might need to do to save your life. So having said that, before we talk about the case, one more thing. I know a lot of you are going to go out and be maxing your credit cards tonight, and I just want to tell you guys, while you're at it, throw a few bucks at the groups that have funded these lawsuits, because without them, we would not have this temporary reprieve from this tyranny. You know, I'm always telling you about the tyranny coming from the state legislature, from the government attacking us, and these groups are the ones that are protecting our rights. So if you can throw some money at the Illinois Gun Rights Alliance, Gun Save Life, Second Amendment Foundation, Firearm Policy Coalition, FFLIL. If you can throw some money at the Illinois State Rifle Association Legal Assistance Committee, do it. You know, figure, hey, listen, you're going to buy a couple boxes of ammo. Maybe buy one box and whatever that second box costs, throw a 20, throw a 50 at one of these groups. Pick one, throw some money their way. All right, so let's jump into this. Gun stores are selling. Okay, gun stores are selling. I reached out to a few of my partners. I have confirmed that they are selling. You can check out Article 2 in Lombard. You can check out the North Shore Sportsman Club in Lake Forest. You can check out Maxons in Des Plaines. You can check out Condition Yellow Academy in Arlington Heights. They have all confirmed to me that they are selling scary black rifles once again. And there's nothing illegal about it because Judge McGlynn says that it's okay. So let's get into this. First off, again, I want to make you aware it is a temporary injunction. It's not a permanent injunction. What does that mean? That means that the judge has issued a temporary order blocking enforcement of the law pending the outcome of the remaining proceedings, okay? And we're just in the infancy of these proceedings. It could take years. So does that mean that this injunction will be in place for years? The answer is maybe. What do I mean? Okay, we know for 100% fact that the state is going to appeal, and they have a few different mechanisms that they can use to appeal. First, they're probably going to ask Judge McGlynn for a stay, basically pausing his ruling, saying, yeah, we acknowledge your ruling, but can we pause it for now? Anything's possible. It is very unlikely if you read the text of the ruling. There's a 29-page document that was put out today. It's very unlikely that he's going to change his mind and issue a stay based upon, like I said, if you read the ruling, he's talking about how, this assault weapon ban is causing immediate and irreparable harm. If that's true, which I believe it is, then it's like I said, it's very unlikely he changes his mind. That brings us to the next step. The state can appeal to the 7th Circuit, okay? Now, 50-50 chance that the 7th Circuit overrules McGlynn. They could, but I say it's a 50-50 chance because when we look at a few other cases, there are multiple assault weapon ban challenges going on right now. If you didn't see the video, I did a video the other day. There's like 19 or 20 cases that I'm following right now, and there are multiple challenges, and a few of them in the Northern Circuit of Illinois. Also federal. A few of them in the Northern Circuit. The 7th Circuit did not overturn the ruling. They were not favorable rulings to us by the federal district. Okay, so basically the federal district said, no, we're going to not issue a temporary injunction. The groups that are funding this, National Association for Gun Rights is one of them. Oh, and I forgot them earlier. You might want to kick them a few bucks also, although they're not involved in this particular judgment. So they appealed to the Seventh Circuit, and the Seventh Circuit judge allowed the lower court decision to stand on that temporary ruling. National Association of Gun Rights, I want to say 2 days ago, appealed to the United States Supreme Court asking for emergency injunction. Will the Supreme Court hear that case? I don't know. They pick and choose what cases they want to hear, so we'll see, and I'll keep you posted. So obviously we know the state has options. This could go away. This temporary injunction might last only a few days. It might last a few weeks. It might last a few months. It might last a few years. Your guess is as good as mine. My advice to you is if you are considering purchasing something that is on that ban list might go back into effect at some point in the future. And if you're considering purchasing something on the ban list, I'd go out and I'd purchase it right now. I'm kind of pissed. I just dumped $1,500 on steel targets for our defensive shooting classes. That's another reason why I'd like you guys to come out and attend the classes. Number one, it's going to be a hell of a good time. Number two, I'm going to make you a better shooter. But number three, I need to pay for my steel. So come on out and check those out. I want to get into some of the language of this temporary injunction. Again, it's 29 pages, and I'm not going to bore you with all the details, but there are some really good highlights in this that I want to read to you guys. So basically, just getting into that, like I said, 29 pages. I won't bore you with all the details. Judge McGlynn in page 12, he talks about the Second Amendment is about more than just hunting and self-defense. The Second Amendment, he says, the additional purpose is securing the ability of the citizenry to oppose an oppressive military should the need arise. And this cannot be overlooked. And that is the intention of the Second Amendment, to allow us, the citizenry, to fight back against tyranny and oppression. And so it's really nice to see a judge acknowledging that in his ruling. So that's on page 12 and 13 of the ruling. Also on page 15, Judge McGlynn acknowledges the Bruin ruling. And so what's the Bruin ruling? Well, last year, the United States Supreme Court ruled, it was the New York State Rifle and Pistol Association sued the state of New York, and basically, it was regarding their concealed carry licenses. Their concealed carry licenses at the time were what we call may issue, which means that you can meet all of the requirements, but if you don't have a need, if the government doesn't determine that you have a need, then they're not going to give you the license. The United States Supreme Court said that was unconstitutional, but as part of the Bruin ruling, and that's why all of these cases, this assault weapon ban case that we're seeing here, Washington State, across the entire nation, all of these cases are basically a hissy fit from the government because they don't like and they don't agree with the Bruin ruling. And so here we are having to challenge all of these cases because of the hissy fit that the government, for example, J.B. Pritzker, the hissy fit that he's throwing his temper tantrum, that's what we're talking about right now. So, reading to you something that we're taking out of page 15 that McGlynn put into writing. He talks about the two-step framework, which was previously part of the ruling. And McGlynn says the court instead adopted a single-step test rooted in the Second Amendment's text and as informed by its history. And so basically, he talks about going on in the same paragraph, the Second Amendment protects the possession and use of weapons that are in common use. And it is a single-step test. It is not a two-part test. What we're seeing is a lot of these lawyers are still arguing the old system of arguing, and that is null and void as of last year. And so McGlynn rightfully applied the new Bruin standard to arguing Second Amendment cases. So that's excellent to see that being included. When we move on to page 28, we're nearing the end here. McGlynn goes on to say, he says, it does not appear that the legislature considered an individual right. No duh. We have the right to keep and bear arms. That is your individual right to be free against tyranny and oppression, to ensure your self-defense. That is your individual right. It is very obvious whenever a government passes any sort of gun registration, gun regulation, gun law, that they are not taking into account our individual right to protect ourselves and to be free against tyranny and oppression, which he did acknowledge earlier in this temporary restraining order ruling. In conclusion, so we're at the end now. He says that irreparable harm, that this law is creating irreparable harm. He says that the plaintiff's motion for preliminary injunction is granted. So the plaintiffs, that's us, the gun owners of the Illinois, filed the case. We're the plaintiffs, and their motion for temporary injunction is granted. It says defendants, that's the state, defendants are enjoined from enforcing the statute 720 ILCS 524 1.9. That's unlawful use of weapons. That was added as part of the assault weapon ban. It talks about paragraph B, C, and so on. What we're talking about here is it's very important to understand that the entire Protect Illinois Communities Act, the entire Illinois assault weapon ban has not been put on hold. Okay, private transfers of firearms July 1st are going to be banned, and to the best of my understanding, those are still in effect because that was not part of the argument that was made. There are things, task forces and other things that are going to remain in effect. What McGlynn did say is the ban on the cosmetic features on handguns and the magazine capacity on handguns and rifles and the cosmetic features on rifles and the capacity and the features on shotguns. Those things cannot be enforced. He also talks about provisions in 735 ILCS, which talks about litigation and things of that nature that can't be enforced as well. So it's important that we understand that there are some parts of the Protect Illinois Communities Act that are going to remain in effect, that have not been challenged, that might be challenged in the future. Some I doubt, some maybe, we'll see. But those things were not addressed in this ruling. Well, they might be addressed later. Like I said, we'll see. So anyways, let's just kind of, the last sentence, McGlynn's last sentence in his conclusion. Judges should exercise their prudent judgment in committing individuals that pose a threat to the public and imposing sentences that punish, not just lightly inconvenience. Now, he goes on to say, inconvenience those guilty of firearm-related crimes. And I want to take offense to the firearm-related crimes. But before we get to that, I believe he's talking about the fact that specifically Cook County judges basically will slap these habitual armed felons, these habitual violent offenders. They just slap them on the wrist. Home arrest, letting them out in a few months for attempted murder. These sorts of penalties are not penalties. They are, as McGlynn said, inconveniences. If you've murdered a few people, I don't know if you should be on the streets. I believe that criminals can be reformed, but if you've got a habit of killing people, probably you're not one of those people. Now, I said I take offense to McGlynn's categorization of firearm-related crimes. I want to throw this out there. If I forget to renew my FOID card and I possess firearms, I am a criminal. It's a firearm-related crime, is it not? Realistically, he didn't say this, but realistically, he should have said violent crimes. I also want to point out that not all violent crimes are used with a gun. You can have a knife, feet and fists. Okay, so all of these things are violent crimes, and using a knife to commit murder is no more nor less heinous than using a firearm to commit murder. But he said what he said, and so I believe, and I could be 100% off base, I believe when he says firearm-related crimes, he's talking about violent crimes. But nonetheless, he's giving direction to judges in lower courts. He's saying, hey, damn it, do your freaking job, okay? So I'm raising a glass to Judge McGlynn. I'm raising a glass to the Illinois Gun Rights Alliance. I'm raising a glass to FFLIL, to the Firearm Policy Coalition, to the Second Amendment Foundation, to the Illinois State Rifle Association Legal Assistance Committee, to Gun Save Lives, to the State Line Rifle Association, to the National Association of Gun Rights. I am raising a glass to all of you. Thank you for helping restore my rights. I have contributed. I will contribute again. Thank you everybody for watching. I'll catch you on the next video. Don't forget to sign up for our defensive shooting classes. As always, everybody, be armed, be trained, and be alpha.